Friday morning, the Virginia Supreme Court issued their long-awaited ruling in the redistricting referendum. As the challenge to the case was on several fronts, they chose to pick the one that used the intervening election law. Ken Cuccinelli sat down and gave us some insight into the ruling and how they came to this decision.
There's a little bit of teasing by the majority in here, noting the 4-day period in between the first passage on Halloween of the proposed amendment and the election day also included a weekend. And by the way, in that weekend, if memory serves, we don't even have early voting then. So early voting was actually over. And the only thing left to do was receive mail-in ballots and for in-person voting on the election day itself on November 3rd, I believe, in 2025. In the half century, just since the 1971 Constitution, now mind you, this is the same process before then, but the majority in the Virginia Supreme Court only counted back to there.
The Supreme Court ruling is based on whether or not an intervening election had taken place. The argument from the Democratic Party lawyers was that it had, because Election Day is only the day you count votes. Ken Cuccinelli takes us inside this decision on the Supreme Court to defer from that.
The General Assembly has approved 63 amendments for placement on the ballot, and voters have ratified 54 of them. In none of those instances did the General Assembly behave the way it did in this attempted gerrymander. They never before tried to jam amendments through while people were voting. They always respected the process before, literally in the last 63 attempts on the part of the General Assembly. And the court then goes on to lament how the General Assembly and the Commonwealth and the Democrats dump on the 1.3 million Virginians who voted early before Halloween, and that they don't matter, that their constitutional right to an indirect say in this constitutional amendment process being brushed aside was brazen, abusive, and unconstitutional. But that's what they were doing. That's what they were doing. And then they go on to counter the arguments, as I noted, on election being one day versus the whole process. They cite cases, not binding, but from all over the country. As I noted, 4th, 5th, 6th, 9th, 11th circuits and the U.S. Supreme Court have all found rulings in various types of cases, at least consistent with the Virginia Supreme Court's ruling today, and there are none consistent with the dissent's position. And that cites all the way back to the beginning of Virginia. So I won't belabor this too much. I would note that there was also some parsing of the English language. We are a plain language state, much more so than a legislative history state. For those of you who follow federal disputes, you'll hear a lot more legislative history. It weighs more heavily at the federal level than it weighs at the Virginia level. I have pinned to my Twitter page a summary of this account, if you will, of the outcome for today. But this is a great day for the people of Virginia. This is a great day for actual fairness, not the kind of squirrely ballot language fairness the Virginia Democrats tried to jam down our throat here with the help of supposedly anti-gerrymandering Governor Spanberger, who flip-flopped on this. And the finger pointing is going to be something to behold. I will get my popcorn and watch the Democrats shoot at each other over that.
As former Attorney General and now the head of the Election Transparency Initiative, Ken also had some insight onto the justices themselves and how the proceeding was argued.
And it's a very sad day. This should have been a 7-0 ruling. I'm sorry to see this extreme example of partisanship on the part of what I'll call the Democrat appointees. That's never been a distinction that mattered so much before in Virginia And I'm afraid that we are heading that direction, and that is a direction this General Assembly, frankly, wants. You're going to hear from Scott Surville, the majority leader. Oh, we checked with all our lawyers. I would note Scott Surville is a lawyer, but not a very good one. And nor apparently were the lawyers they checked with. I challenged him on Twitter to name those lawyers. He won't do it because first of all, none of those lawyers want to be named. But I'm sure it was Mark Elias and his firm and, Hakeem Jeffries' lawyers and so forth. They weren't Virginia lawyers. And my last comment as a former attorney general is some disappointment with Attorney General Jones in importing a lawyer from California to argue a Virginia state constitutional case. Unlike the federal constitution, which a lot of us deal with as lawyers, various parts at various times, very few people in the legal profession anymore, after the New Deal era, really operate and deal with their state constitutions. I would note that on the Virginia Supreme Court are two of literally the greatest experts in Virginia on the Virginia Constitution. If I could name on one hand lawyers who are the premier experts on the Virginia state constitution, Justices Steve McCullough and Wes Russell would be among them. Both of them litigated the state constitution. Steve McCullough, for years before they went on the bench. I would also name Bill Hurd, former Solicitor General of Virginia, and Pat McSweeney, who was there when they wrote the 1971 Constitution. And I've still got a finger remaining. And so two of those four are on the Supreme Court. They led the questioning. It isn't just because they had questions about this. They literally have more experience litigating the Virginia Constitution than almost any lawyers in Virginia.
Current Attorney General Jay Jones issued a long and somewhat hard to figure out statement in which he claimed they are going to continue to fight for the voters of Virginia. Ken Cuccinelli made it very clear that there is no other recourse in this case. This is it. It is done, he said. But he also said a couple of things about Attorney General Jones and the Solicitor General he chose to argue the case.
The institution that holds the most experience litigating the Virginia Constitution is the Attorney General's Office of Virginia. And yet our current Attorney General, Jay Jones, did not look to one of his own lawyers in the office to argue and lead this effort. And that is mystifying to me. I don't understand that. I can only conclude he doesn't trust either their abilities or he's paranoid that they won't agree with him or argue sincerely. They're professionals in that office. I think that was a bad judgment on his part. I think it was a mistake, though I don't think it would have changed the outcome. I think within the legal community, that will be found to have been a peculiar decision on the part of our current Attorney General. I hope he doesn't make that mistake again in the future and he respects the people in that office. I certainly did when I got there. And on no issue does that office have a greater advantage over the rest of the world than on matters relating to the Virginia state constitution.
So that's that. Virginia's congressional districts will stay where they are. Now, that said, there are very contentious battles in several of the districts that may see midterm election flips, but that's to be seen in a traditional layout of Virginia's maps as they were determined in 2021. The Supreme Court ruling again 4-3 along party lines in favor of the plaintiffs in the case, tossing out the referendum because it was come to in an illegal fashion.
Folks, all of the history here, the history of the Commonwealth, the history of the Constitution, the history of the amendments to Virginia's Constitution, both distant that set this process up in the 1870s and recently in the 1970s, the most recent rewrite, all support the majority's conclusion, and the dissent doesn't cite to any of it because they can't. They can't rely on the history or legal tradition of Virginia because of how brazenly the Democrat Virginia General Assembly trampled that history, tradition, law, and precedent in attempting to jam this gerrymander through for 2026. Well encapsulated in Louise Lucas's 10F and 1 t-shirt. shows real respect for the legal process about the amount that you would expect from Louise, but also the amount that was shown by this General Assembly. And the Supreme Court rejected that trampling of Virginia's constitutional requirements. After they walk through that and find that the use of the word election, election day, general election, there are many different uses of that in the Constitution and statutes, and they read them all consistently, and they point out that if the dissent's version were accepted, all uses of election and election day, all of them, would refer only to the one day, which wouldn't make any sense, even in the early voting statutes that the dissent itself cites to. So they are really attempting to rewrite history and the law to achieve the outcome the Democrat General Assembly that they have clearly bowed down and groveled to here wanted.